Carlos, is there a lot of people out there? Okay, great. Yeah, yeah, you can wear that. Are they on? Are they on? So if there are any Florida lawyers in the room, CLE, um, we'd still do the old-fashioned printing but I don't think you need any of that, right? So there are copies of the CLE approval. Yeah, they're outside, but in case, well, Nathan gets it hand delivered. Which eagle are you? Which eagle are you? Which one's your brother?
I know the names of the two birds, Sagax and Avrox. Yeah.
There you go, Leonardo brothers. Yeah, Luis Sagas, or not? There you go. You see, you've been nicknamed. Okay, Mr. Concepcion, be respectful to the webmaster, please. People, it's not that hard. You can do it. You can do it.
If you want, yes. If you want.
So if there's anyone going to the cocktail reception at the ICC, at the Loews Hotel, we have arranged for a bus to take you there. It's going to be waiting for everyone in the parking lot. And that was Mr. Francisco Rodriguez's idea. That was a great idea, actually. So, El Comandante. So, well, he says to thank him if it works. If it's not, it's FIU's fault. Right, right, exactly, exactly. Do your microphones work? Okay. I don't know if you want to start because otherwise, people are not taking this seriously. You can cut that from the recording, right? You can edit later. Yeah, you can edit. Please do.
Great. It's a little bit of echo, no?
Do you want to start?
I think so. We can start.
Can you
no?
hear us? Maybe we should not.
Yeah.
Yes. When we dance, we should stay
In
far.
distance.
Yeah.
So,
Good afternoon, everyone. And I think we should start our Tilney Old Style session. And when I saw that we were using, we have been using this name Tilney Old Style, I immediately, of course, thought of the LCIA. And yesterday, when I saw Kevin Nash, the Secretary General, said I mentioned that to you, and he was very happy that we use this for our format. So I took that as a formal endorsement of our session today. And yeah, we should probably cut it off. And before we started, there were some chairs and tables here, and I jokingly said that Julio and I were going to dance on stage, and then they removed the furniture, and then I'm a little bit scared because maybe now they expect us to
We
do
need
something
to-
like that. I will leave that to you, Julio, and
Well,
it's I think
maybe
it's the safer
with
the
some more
safer
Prosecco.
bet. And jokes apart, thank you very much for staying over after a beautiful lunch and a pretty impressive interview by Enrique to Doc Bishop. Was really professional. I was truly impressed. I did not expect anything less than that, but you did amazing. Well done. And also congratulations, yes, congratulations on Mias on organizing an amazing event once again. And of course, thank you for involving me with this session today. It's been really amazing, and I'm very proud to be
Yes.
part of this team. And you want to say something before?
No,
we
of course,
start,
I
Julio?
just want to echo what Domenico said. It's been an impressive series of panels, the insights, the discussions, the interview, the lunch. Thank you for having us. And I think there's been many topics and many interesting things that have been said during the panels. And well, this space is now for you guys also to tell us what you think, to contribute, to participate. Needless to say, of course, Chatham rules apply, so feel free to speak your mind. You won't be quoted on that. And we have a list of issues, many of which relate to some of the topics, again, that were discussed earlier today. And do you want to, Domenico, start with?
Yes. Just one thing. We're going to ask questions. Unlike the traditional Tini Hall style discussion where the attendees actually submit their questions, we came up with a number of issues that we thought would tie well and with what we have discussed in the previous part of the program today, as you will see. But then, of course, as we develop our conversation today, there will be a chance to move and maybe develop or take a discussion, a line of conversation that would take us somewhere else, and feel free to do that. Chatham House, you're here. Whatever we discuss, this stay here. So feel free to exchange views and perplexity that you want to, or perplexity, I can no longer use perplexity because now we say AI, right? So we should be, clear that we are not using AI. And yesterday I made myself clear about what I think of AI used by arbitrators, and maybe my career as an independent arbitrator finished right there. The first issue that we would like to share with you, and this is something that came up in both of the two panels that we enjoyed earlier today, and is the issue of the rights of indigenous people, and as a result of the development of that issue, the obligation of investors to run a meaningful due diligence on the characteristic of the states that they are going to invest. But let's start with the rights of indigenous people. And this is particularly relevant because I was looking at a study. I was involved in cases dealing or somehow tackling the rights of indigenous people. And most of the recognized indigenous people in the world are in Latin America and the Caribbean, generally, depending on the definition of what Latin American is. I think it is very expansive notion. But we have those rights that have been codified in international conventions. As you know, the ILO 196, and that is a binding instrument for the states that, of course, subscribe to that, and it's been around since 1991. So even before the wave of bilateral investment treaties that we know. So it is a concept of public international law that most states and therefore many investors should have been aware of. Now, whether that, and of course the 2007 declaration, but that is not a binding instrument. But it's still something that could be argued to be part of public international law to an extent. Now, we are all aware of the rights of indigenous people, and from a practical point of view, most of them happen very close to sites that are very interesting in terms of mining, in terms of construction, of big sites, both in terms of dam or in terms of other projects. But they are definitely affected by these investments and projects that are backed by the host state. Now, we are under the impression, and Julio and I, correct me if I'm wrong, Julio, and the impression that possibly the missing chain, the missing element in bilateral investment treaties, but also in investment arbitrations, is the relevance of those rights, the rights of the indigenous people. So, for example, I was involved in a case about a gold mine in a certain Latin American country, and somehow the rights of indigenous people came as a very side issue. The only issue was whether the indigenous people were consulted in compliance with the provisions of the ILO 196, but there was never a discussion whether compliance with that instrument of public international law would affect somehow the obligation of the state to provide certain standards of protection. We discussed today food protection and security. And we will see later possibly issues of corruption. But I would like to know, and we would like to know, whether you have encountered an issue of the protection of indigenous people in investment arbitration. Anyone here? Raise? Okay, we have 2, 3. That's good. So I expect comments from you in a second. And whether, from your point of view, you believe that the way the rights of indigenous people were entertained in the arbitration somehow reflected the idea that was codified in public international law instruments, both binding and not binding.
And just to add a quick comment on that, I mean, and as Domenico was saying, I think there's been an evolving trend in recognizing these rights and incorporating them in some new generation treaties. But the question is also very interesting with what happens when there's an investment under a treaty that does not include such language or does not recognize such rights. There's also, I mean, in those cases, are investors also required to follow a procedure? What if, for example, domestic law says nothing about it? What procedure must they follow? There's no standardized due diligence procedure as such. And so I think these are very practical questions, which both tribunals, counsel, just parties face in Latin America. And as Domenico said, it would be great to hear your experience on these issues. Yep.
Yes, Luis? Oh, you want a microphone? No. Yeah, yes, so let's give it to him, yes.
In my experience, most countries, particularly in Latin America, recognize the rights of indigenous people. people, and in fact, it's part of the regulatory process. You don't get to go ahead and develop a gold mine, a highway, dam, unless you go ahead and actually deal with indigenous people. And to be crass about it, the way I've viewed that is, basically you've got to give them their slice of the pie. So you go and pay them off, and then they're happy. The problem then comes up is that another set of indigenous people say, well, that was the last mayor or whatever. I'm the new mayor, and I expect my own, it's a different group of people, and then suddenly, when you thought you had an agreement, well, now you don't have it anymore. And that's where I think the state comes in. If you go ahead and comply with the state regulations, and it says you have to meet, and again, they all say it, you have to meet with them, you have to come to an agreement, and it has to be voted on, and that happens, and then you get stamped by the Secretary of the Interior saying that you've met that, and then you have to go and meet all the environmental stuff, the whatever other regulations of the state. Whether or not that may meet another treaty, I'm not, I haven't run into that. But the issue of dealing with indigenous people is front and center in every major development, particularly that I've ever dealt with. And the problems come when there's disputes within the indigenous people saying, no, we really haven't been taken care of when you thought you had.
No, I see that. It's a very good point. Thanks, Luis. My comment in this respect is that sometimes there is a dispute as to who is actually responsible for carry out or taking responsibility for that requirement and consulting the indigenous people. Because foreign investors might tell you that, so we don't have the power, the authority to carry out those consultations. We don't have the authority to gather or to call for a meeting. People may not show up, they don't respond. So they say it's a state responsibility to actually gather and the indigenous people to make sure that there is a way from consultation or a vote or an expression of concern that the foreign investor can now take into account, and at least being able to tick that box that they need to show that they are carrying out the investment in compliance with the laws of the country they are investing in.
But again, in my view, that's all spelled out in great detail. So they'll go ahead and say, you have to meet with the local mayor, and you have to have a town hall, and it's all very well spelled out. Sometimes there are problems. They go, I don't know who to deal with, and then you have to go to the state authority and say, help me out. Who am I supposed to deal with? Because as you correctly point out, the investor is coming from Canada. They have no idea who to deal with. So they go ahead and they follow the procedures, and the state starts to say, well, you have to do this and you have to do that. And then the state certifies that you've actually done it. Once the state certifies that you've actually done it, and then suddenly a dispute comes up, well, now that's where we talked about, you have to give me full protection. You can't allow the indigenous people to start attacking the pipeline.
Yes.
Because I did what you suggested. I've gotten your seal of approval. I've done all these other permits. Now I'm trying to develop it, and you have to provide. The only thing, the principal purpose of the state is to provide security.
But what
Yes.
about? Sorry.
No. My follow-up reaction, but I don't want to really monopolize the conversation here, is that the practical problem that I have seen many times is that, for example, around one site there are 2 or 3 different groups or tribes, and they all have different views as to how the problem should be approached. And normally the local mayor is not in a position to really manage that situation. And sometimes the local authorities have different plans that are in contrast with the plans of the central government. And this is something that we have seen even in situations where there are no indigenous people involved, especially in Latin America. And any other, Carlos, you wanted to say something? Carlos Concepcion.
Just a few comments on that. I completely agree with what Luis's observations were. The bottom line, as I see it, with respect to this topic, is that this is fundamentally important that you do your due diligence at the very beginning. The investor has to understand that the indigenous folks are part of your investment, they're part of your community. You've got to work out a system with the government and the indigenous folks at the very beginning. And what I've seen, the best approach to deal with that typically is these consultants. There are many of these consultants on the ground, but you've got to get these folks involved with the negotiations. They have to have a sense of ownership and entitlement in the project, and they do, and it has to be respected. And the only way to do that is to get them early involved in negotiations, get the state involved in the negotiations, find a way to have these folks understand that this is in their best interest. But if you don't pay attention to them, and if you ignore them, and if you don't deal with the reality on the ground, you're going to pay a big price later at the end of the day.
And just to, add to the stir and hear your comments on, but I agree that nowadays many Latin American countries have domestic laws that regulate social licensing, but Mexico is one of the most indigenous countries. We have hundreds of indigenous communities, and it was not until recently that that was actually codified. The government did not require you to get a social license, like approval from local communities. And so we've seen some cases where the investors were not required by local law to go through that process, nor was there any provision in the relevant treaty. And so, in those cases, what do you do? Because that's the case in Mexico for the mining industry, for example. Now it's required, but it was not until recently.
So one of my observations is going to be that not every jurisdiction does have everything codified in terms of social licensing, but even in jurisdictions where you do, there are instances where, yes, you go through the process, you go through all the meetings that you should have, at least paying lip service to every requirement that is in local legislation, and then at some point you get a rubber stamp, whether it's at the municipal level, state, or federal. But even then, most of the cases that you see where there's a social licensing issue, there was a certain amount of diligence and a certain amount of effort put forth by the investor, and they did have some sort of rubber stamping. But the argument sometimes is, okay, sure, but that didn't comply with ILO standards, or it didn't comply with some other precept of international law. And in that setting, what they're trying to do is sort of foist it on the investor and say, well, okay, this is on you. But I think, going to your question, I don't think that's fair. I think if there is a standard that is codified and you meet that standard and you get a rubber stamp, and that's not up to international standards, that's on the state that legislated. They've lowered the standard that they will accept, and you met that standard, right? And I think it's up to them to heighten it or to meet international. If not, they need to be transparent in terms of what is required and what kind of behavior and what kind of diligence is sufficient and what simply won't be.
Yeah.
And for those that, for jurisdictions where you don't have something codified, then I think the onus is somewhat shifted in that you do need to know, you need to go into a situation with your eyes wide open and know what your international obligations are. Now, I do think it's only fair that if you put forth a reasonable amount of effort and diligence, that you are not then punished for not meeting an arbitrary standard that was never materialized domestically or at least legislated.
Yeah. No, I agree with you. And it's sort of also like an ongoing responsibility, right? Because, that's like, Luis they were saying, communities can have different leaders at different points in time, and then what happens if there's an expansion of the project? Suddenly they want, their cut of that slice as well. And there can be protests, and so it can get definitely complicated. But there was, a comment.
Yes, I think the problem is really easy to solve because ILO 169 is not a self-enforcing treaty. I mean, it needs implementing legislation by each contracting party. So if the state fails to implement this legislation, it is obviously the state's fault. If you as an investor follow all the rules of the implementing legislation each state passes and it doesn't work, because as Luis said, by granting this privilege under the guise of indigenous people's rights, you're just really creating an extortion industry. That's what it is. It's an extortion industry. And all these interest groups are just going to try to get as much as they can from an investor, and most of the time they don't even respect the decisions taken by the indigenous people.
Yeah.
I mean, there are some groups, they vote, they get this consultation, they approve the project, but the other section of that group just doesn't respect that. But as long as you follow the rules of each state, I don't know how can it be the responsibility of the investor. What can you do? You are following the rules that each state implemented. And if you haven't implemented any rules, like the case of Guatemala, then it is your fault.
Yeah. No, I see your point, and I think the worst thing that can happen to investor is going to a state where rules are not clear, and then be held responsible for not doing something that they were not required to. But it's, I mean, in some awards, you see that. You see tribunals quoting international standards that are not part of domestic regulation. So I definitely get your point over there.
Yes, well, coming from Mexico and having worked in the government and looking at other discussions outside of investor state, for example, under international trade law, Mexico recently had a case under the USMCA for genetic modified corn. And part of the arguments of Mexico were also the indigenous rights as part of the culture or the rights of these indigenous groups to preserve their ways of planting or producing corn. Mexico was not successful in that defense under Article 20 of the GATT. And I think the problem is part of the problem is because, as you mentioned, there is already a legislation, and the question is whether you apply that legislation or not. The other is, how do you really can demonstrate that these groups are really indigenous groups? So if the regulation is not very well drafted, you can get then suddenly people of NGOs and with other very different interests saying they are protecting indigenous rights that are not legitimate in themselves.
Yep.
So someone else is bringing these claims for other political interests, and that's very difficult to maneuver because it becomes a very sensitive issue for the governments to say that they are not protecting the indigenous rights. So I think the problem for investors is when the government starts adopting regulations and the investments are already there. Or when the investments are already occurring and then suddenly these groups appear out of nowhere. And in Mexico in particular, that's very difficult because if you construct a gas line or a gas pipeline,
You certainly will go
everywhere
through
you start digging, there will be you will find some settlements of previous indigenous communities, and someone will raise all that. Those are my great-great-grandparents' interest of them, or the culture of Mexico's interest. So you could have a lot of problems into developing any kind of project in Mexico if you want to set a specific standard. So I think that's a very huge problem. Actually, in one case we were involved. Sorry for this extensive
That's very interesting,
intervention. In one case, we were involved in a construction of, how do you call it, an energy, water energy plant, hydroelectric. And obviously you have to dig and do a lot of maneuvers there. And I understood at that time that every time the government finds that there is some
Archaeological
archaeological
finding.
sites or findings
Yeah.
there, what they do is actually they don't have the money to restore or do anything. You say, okay, what's below this? Okay, you cannot dig here and put the land on top of it and continue with the construction. Because obviously that, if you start doing a lot of noise and recovering all of that, then you start to have all these groups. So the government is aware that there is a lot of sensitivities with regard to any project in Mexico. And I think that if they don't have clear regulations, if they don't identify these groups, if they allow people to claim themselves as protectors of indigenous rights, this will be an ongoing risk for all the investors.
Yeah.
So that's a very good one. Thank you for your contribution. And it seems to me that the problem here is one of identifying a standard or a threshold that would tell us whether the foreign investor did enough, somehow at least attempted to comply with their obligations, if an obligations on the foreign investor exists, to make sure that eventually an arbitral tribunal would not bar a claim or would not uphold a defense based on the fact that the rights of indigenous people were not respected in their respect. So it's really an issue, correct me if I'm wrong, Julio, one identifying whether there is an obligation, because the issue of whether the ILO 169 is self-enforcing within the state, there might be an issue of whether the state was actually under an obligation because of constitutional rights to actually enforce their convention by domestic legislation, but did not do that. And that is, maybe a source of responsibility towards the foreign investor or the indigenous people. And if we found ourselves in a situation where the rights of indigenous people are codified also at domestic level, what is expected of the foreign investor to comply with that situation? I don't want to call it an obligation. Yeah, we have here.
Just for completeness, not because I disagree, you've touched upon the whole regulatory piece and what if the regulation existed before and what the standard was and what if the regulation is passed after you've already invested and you have sunk your costs and all that. I think we're disregarding one pretty critical piece as well, which is what did your concession or your contract actually say? Because there's going to be very relevant provisions while dealing with the access rights. Nobody makes these types of investments without having clarity about who has the obligation to grant access, does the government have an obligation to cooperate, where does, how far does it go? And the other piece of it is, that I've seen it come up, is in the context of force majeure. Because depending on how the situation arises, is it force majeure, and then what happens in a situation where you want to get damages as an investor, as an example, or as a state, sometimes the solution for a force majeure situation such as this one would be simply the extension of the term. But in some business cycles, that's not going to really be redressed. So I'm just saying, I think the grant, whatever it is, if it's a concession, if it's a production sharing contract, if it's whatever contract you received, is going to have a lot also on this issue.
Yeah. No, I think that's right. But maybe we can move on to the next topic. And the next topic that we wanted to discuss with you, which was also briefly mentioned in one of the panels, was corruption. Corruption is a reality in Latin America, and especially in concessions, public contracts. And so it's front and center of many disputes being raised by the state as a powerful shield to dismiss claims, and which of course pose an existential threat to the investor's claim. So One of the most salient issues on corruption is the standard of proof. What should be the standard of proof used by tribunals? And should it be clear and convincing evidence because it is an important allegation being made against the investor that the investor procured its investment through corruption. So the state needs to prove with clear and convincing evidence that that was the case. Is it a balancing of probabilities, more acute to the civil standard, where the tribunal will weigh the evidence, and then if it's more likely than not that corruption happened, then you can have a finding of corruption? Or is it just more contextual? So is the standard even lower? Is it just a matter of providing circumstantial evidence, a collection of red flags, based on which the tribunal can make an inference? And the argument there is, well, it's very difficult to find direct evidence on corruption, so maybe that should be the standard. But we would love, again, to hear your comments on this, your experience on cases, and what do you think the standard of proof should be?
One thing that I would be very interested in knowing from, we have a very experienced audience, so would like to take advantage of that. Have you been involved in cases with a corruption element of defense? And what type of if you can share, as much information as possible, and what type of defense that was? What type of circumstances the issue of corruption came up?
Anyone?
Anybody? Yes.
To me, this is a very important issue for investment arbitration. I think the investment arbitration system serves a very important purpose with respect to the eradication of corruption. Because at the end of the day, the same way that a state violates a treaty when it exercises its discretion in an arbitrary, discriminatory manner, it also violates the treaty when it exercises that discretion in a corrupt manner. And obviously, there's no amount of due diligence that could be done to prevent that, because at the end of the day, the commitment when that state goes out and tries to attract foreign direct investment is that it's going to be fair, equitable, and that irrespective of its practices, that investment is not going to be subjected to corruption. I have a hard time understanding why we need a higher standard of proof. The reason for a higher standard of proof in criminal cases is because you have incarceration, obviously, the potential for incarcerating a person, and that implicates a number of human rights, a number of due process concerns that requires the state to prove before sending somebody to prison that that person is indeed guilty beyond a reasonable doubt or by clear and convincing evidence in other jurisdictions. Preponderance of the evidence is a standard applicable to every element of a claim, and that is a standard that should be applied to the element of corruption. Now, I also see that we should see more cases in which corruption is used not only as a defense by the state to prevent an investor from exercising or claiming the protections under the treaty, but also by an investor claiming that its investment has been undermined by corrupt practices by the state, and that should be subjected to preponderance of the evidence as well, as another element of the claim.
Thank you. It's very interesting. I think I agree with you. I think that's the prevalent view. Those that argue that it should be a higher standard is just because even though, of course, the value or what's at issue is not the freedom of someone, it could be at stake an entire company. and with serious allegations should come a higher standard of proof, but I agree with you.
Yeah, and before we go there, I think the issue is that there is a little bit of confusion, and you seem to be hinting at that when we look at corruption as a crime, and
Yeah.
then for the commission of which you go to jail, and corruption as a source for compensation under bilateral investment treaties or customary international law generally. But the standard should be the same as the standard for proving breach of fair and equitable treatment, or for failure to compensate an expropriation.
Mm.
Luis.
I'm going to take a slightly more nuanced view of this. First of all, I have fundamental issues with the concept of corruption, because the state is fine with corruption until it decides, oh, I don't like the investment. So I'm shocked. There's gambling in the house. That kind of thing. I have a problem with. But that may go to the question of remedies. As to the standard of proof, I wonder if we're making a bigger deal of it than it really is, because I think, as we've all mentioned, it's difficult to prove. And whether you call it a preponderance of the evidence or beyond a reasonable, I think tribunals will make their own judgments of it, and the award will reflect their true understanding of what happened. If they see a situation where they believe corruption really took place, but they can't, I think the award will reflect that, whether or not they really go through and say, oh, this meets the higher standard burden of proof. By the way, even in say, U.S. law in a civil capacity, if you're trying to prove fraud, you have to prove it with clear and convincing evidence. It's not beyond a reasonable doubt. There's a higher standard. Whenever you go ahead and try to allege fraud or corruption, there's generally a higher standard. Again, whether you call it a higher standard, you call it a preponderance of the evidence, I believe tribunals will adjust their reasoning to what that.
That is a very interesting point, actually, because I think that because it's very difficult to prove, but of course you have many elements pointing towards the fact that maybe corruption took place at some level and at some point in time. So maybe that element will stick to the mind of the arbitrators. They might be more inclined to find in favor of the party that was lamenting corruption, but without actually finding on corruption, because it's difficult, and there might be when you find for corruption, then it's like you start a wave that you never know when it's going to end.
Yeah.
And that is actually a very good point. Yes.
I think that when we talk about the standard of proof, it can be a little bit artificial if you take into account who the disputing parties are in an investment arbitration, right? So it is the state that is raising, usually, corruption as a defense in a jurisdictional setting. And it is also the state that has police powers, that has investigation powers, that has a comptroller's office, that has all these resources at hand that do not exist for the investor. And so for the state to say, I get to have a free pass here, I get to not pay this debt that I know I owe you, or whatever it is, because there may have been some corruption, and it's hard to prove, but I'm going to just kind of throw a bunch of stuff here and let you figure it out. And let's talk about flags or preponderance of the evidence, etc., but then not proffer any evidence from its own state authority where it is liable as a whole, right?
Yeah.
And saying, oh, well, I don't know, it's old, I don't have the papers, but I promise there was something there that prevents this investor from getting access to a claim. And it's not just that because they bring it up when they don't like the investment, as Luis was saying, is when they don't like the investment claim, right?
Yeah.
It's like when you're actually in arbitration, there's all of a sudden there's all this noise here. So I think that is important to keep that in mind, is in the context of corruption and also in the context that we were talking about before. Is like, who is your disputing party and what is it that they have access to as a whole in an international investment case?
Yeah, I think that's a very interesting point, because I agree with you in that a bunch of red flags is not itself proof, right? It's just a bunch of red flags. So indirect evidence doesn't prove per se something. But I mean, taking the other stand, may collection of validated red flags, I don't know, somehow, if not prove something, shift the burden of proof. Because even if I totally understand and agree with what you're saying, that the state should have all the records. I mean, I also see why they might not have them. Maybe they were destroyed by the officers that were involved in the acts of corruption. So I don't know, but maybe that a procedural way in which you can sort of find a solution is just shifting the burden of proof at some point. No. Yeah, no, I see how that sounds opportunistic, and I agree with you. I just, for the sake of the argument, I was playing the other side. But
Let's see Giovanni Angles.
I took the microphone from you because I'm agreeing with you. On top of what she said, though, it's even worse than that, because the other party to the corruption, right, if the investor's being accused of corruption, is usually themselves a state actor.
yes,
It's a mayor, it's a governor, or it's someone from a regulatory body so it's even more of an onus, I think, or I think it's even more problematic to allow states to get that easy of a way out to be able to claim corruption when technically it is state actors or instrumentalities of the states themselves that are perpetuating it, or it's the perhaps within the legitimate expectations of the investor when they first arrive at the scene. That is the framework with which they're working with, and it seems a little unfair to give states that much power.
yeah. And that, I think that raises also another important point, which has an impact on proceedings, which are criminal proceedings that are being dealt by the state. How are they going to impact the arbitration? You have the risk of an inconsistent award or findings of the judgment and the criminal trial. But yeah, Luis.
Julio, I was going to go exactly to that, following up on Estefania. If the country feels that there is really corruption, well, where is the prosecution, not just of the investor, of the manager that was paying the bribe, but of the minister, the mayor, and whatnot? By the way, just because there is a criminal proceeding doesn't mean that they're guilty.
Yeah.
We've all understand that there are proceedings that are brought just trying to incarcerate witnesses
Yeah.
and whatnot. But in this whole thing of burden of proof, if you're going ahead and alleging some kind of criminal behavior and you haven't even brought criminal proceedings, well, why haven't you? If you don't have the proof, then why are you alleging it? And if you do have the proof, why haven't you brought it? So I do think that the concept of criminal proceedings is important in that,
No, for
in that
sure.
regard.
I think it does go to the seriousness of the defense, right? If they actually think.
Yes, but not only that, the characteristic, because you may have that defense when you are alleging corruption within the central government, but then when you have the corruption at the regional level, and it is understandable that the central government may or may not know what was going on when that concession was given at the regional level, and then of course, but you know, when it's the foreign investor brings an investment claim, will bring the claim against the state, not the regional government. A regional government may be involved at some stage and to a certain extent in the investment arbitration, but not as, you know, the real defendant in the case.
Yes, I was going to say that to me the clean hands doctrine is the epitome of hypocrisy. But also that I don't know what the standard is, but what should be, according to me, is the presumption of innocence is, I think, one of the legal recognized principles in international law. So everybody should be presumed innocent. Second, I don't think an investment arbitration panel is the appropriate forum to decide if somebody is guilty or not of corruption. So a defense like that should not be allowed unless it has been prosecuted and convicted. Otherwise, it's just hypocrisy and opportunistic.
I mean, that's certainly one way to view it, and it also goes to the point of, you know, having corruption treated as how are the criminal proceedings going to affect? Should you stay the arbitration proceeding until you have a final decision of the criminal court, local courts, or not? But it is relevant to, of course, the admissibility or the jurisdiction point, right? As depending on when the corruption happened. But I don't know, maybe, Fernando, and you also had one comment.
Yes,
but
okay, great.
Sure. So I think if we are saying that you need to prove corruption and you need a criminal conviction, then the problem is general investment arbitration goes at a different pace
Yes.
than local proceedings. So you cannot expect a conviction unless you stay the arbitration for like 10 years.
And
We
that,
all know that
yeah.
that criminal courts in most jurisdictions are very slow. It's very difficult to get a corruption criminal conviction. So obviously you have to rely on red flags, and the tribunal will have to decide this issue on if there is
Based on
a
red
corruption allegation. Unless, you know, I don't think anyone is expecting an arbitration to be stayed for 10 years or so until there is, you know, a decision on the criminal case. I think that's unlikely. So then the issue would fall into the arbitrator's hands, and then there is where is the standard we apply. Obviously, if the investor asks for a criminal conviction, that's not going to happen, at least in the near future. So then you have to rely mostly on red flags. That's what the evidence existing at the time. So I think you can have it both ways. I mean, if you're expecting a criminal conviction, then you have to stay. If you say, well, that's not necessary, then you have to rely on red flags.
Yeah.
But you can have it both ways.
Yeah.
Javier Francisco, and then you again.
And building on that point, and again, when we talk about corruption in the context of investment arbitration, it's not only a defense available to the state, it's a claim available to the claimants, particularly when you have a BIT that explicitly, where both parties, both states, agreed to fight corruption, as we see in some of the newer treaties. So from that perspective, that's an important distinction. But I think at that point, you have to divorce it from the criminal proceedings. There are a lot of reasons why an attorney general or prosecutor does not charge a crime, either because you have a new government or because there are allegiance there. And I think that tribunals should not surrender their jurisdiction to determine an issue brought in front of them. Otherwise, you do have to stay pending criminal convictions. And then what is it? Criminal conviction on the first level or an appeal from that process? I think tribunals are equipped not to incarcerate, not to find somebody guilty, but to make a determination as to whether there was corruption in violation of the treaty or as a defense presented by
Yeah.
That's a very good point, because one of the issues that you encounter when you rely too much on either domestic law or domestic proceedings is, in fact, you are applying a different standard, because an international claim should be settled by applying public international law and not domestic law.
Yeah.
So whether there is a corruption for that domestic law doesn't necessarily mean that, an arbitral tribunal applying a bilateral investment treaty or a multilateral treaty or even customary international law should find that there was something wrong, and therefore how that something wrong should affect the claim.
If I just may add
Yeah,
one quick comment, and I agree with that. Something interesting, because now so far I think we've been focusing or discussing the scenario where you don't yet have a conviction or a final judgment. But what happens if there is already a final judgment, where you have a higher standard of proof? I agree with you, Domenico, in that it's different. They should not necessarily defer to like local law and local judgments. But in my experience, most of them do. And particularly maybe in these cases where you have a higher standard of proof, where the evidence was presented, the full case was fleshed out before the local court. I've seen in many awards that tribunals do often defer to local judgments, which again raises another series of questions. But there was another comment for you.
Yes, here again. Just a second. I will give you a microphone, please.
The point is, my point was not that you should wait to get a conviction. You are assuming then that the Corruption Act happened yesterday, or just after the claim was filed. No, the alleged corruption allegedly happened many years ago. So at least you will have to show that you have prosecuted that case, not just raised the issue after the claim was filed. That's the hypocrisy.
Yeah.
I'm not proposing that you have to wait for a conviction, but you're assuming that corruption happened just yesterday, so
No.
we have to wait 10 years.
And that's a great point. And sometimes actually, corruption is not raised even, in the first instance. Often corruption is raised later in the proceeding. And so is that, like a guerrilla tactic? And how should the tribunal deal with that? Because if it's raised at the forefront of the proceeding, maybe you bifurcate. There's ways in which maybe tribunals can deal with it more efficiently. But what happens if it's just, a month or two away from the hearing, the merits hearing? So,
one other aspect, because what you said, correct me if I misunderstood you, is that corruption didn't happen yesterday, but maybe it happened 15 years ago, 20 years ago, when that concession was given on a basis of a bribe, and so on. But then, in that case, you can justify the fact that maybe a government 20 years later only comes to realize that there was something wrong with a certain contract, because there might have been a contract, not a license or a concession, but only realize that there was something wrong in the context of an arbitration. Because then either you go back and see what happened, how did they get this contract? I know, that's why I was suggesting before that it really depends on the circumstances of the case. You cannot have a single rule that should govern issues of corruption in investment arbitration generally, because very much depend on the time frame, on the circumstances, whether it's an issue that would affect the central government or is something that is a regional government level, and this is why, if I may say,
and
it's a
also
beauty
to add to that, just also how central to the investment it was, because you might, and if there's a casual link to the investor or not, because there might have been corruption, but maybe not directly procured. So again, you enter into how much should the investor have known. Was it willful blindness, or was it really something that there, even with due diligence, with a good compliance program, it wouldn't have been able to identify. So, but I think we have a few more minutes. Do you want to?
No. Just if you want. This is something that is interesting. We only have maybe 10 minutes left, because conscious of the fact that there's going to be coaches or buses or whatever you call them going back to the ICC thing. And we have an issue that I think is very important, not just because of the, the audience that we have,
Yes.
is the issue of third-party funders.
Third-party
We want to
funding.
introduce them.
Yes.
You go
So
ahead.
we wanted to also to briefly touch upon third-party funding, and I think again another important trend in Latin America is third-party funding, which is a reality, and so there's a different host of issues or complexities that come with that. There are, of course, the people that are in favor and say that allows claims, meritorious claims, to come to arbitration, to have access to arbitration. And then on the other side, you of course have states which might argue that third-party funding can have, can interfere with any type of settlement with a claimant. And so it raises very important questions. So we wanted, again, to hear your comments on third-party funding, your experience, for example, the disclosure obligations, how much should parties disclose? In your experience, do you think that third-party funders actually influence in any way in any settlement negotiations or not? What's your experience in that?
Also, how you see third-party funding affecting the practice of investment arbitration. Well, because third-party funding is a relatively new animal, right?
Yeah.
And whether third-party funding has affected the practice of international arbitration or investment arbitration more specifically, and how? Please.
Thank you. I'm welcome other views. The only one I heard about the critics of funding is that it can interfere with settlement. That's just a misconception. Like I have worked in funding for years, and I never ever once see it in practice. It just is a contractual agreement when the funder does not have contractual rights to interfere with settlement. It's as simple as that. I mean, it can be exceptions, of course, as any contractual agreement. You can agree otherwise, but the standard is that is not what happens in practice. So unless there is other critics, I'm very happy to take it, but I think that's just a misconception. It's not a real.
Yeah, and actually, I'm gonna add something in favor of third-party funding, which is it can sort of work as a gatekeeper, right? Because it's allowed, after all the due diligence that of course third-party funders do, I think might signal to the state that there are merits to the claim and incentivize a settlement. So not only what you're saying, which I mean, I've never worked in a third-party funder, but I certainly see how that's the general practice as you were describing it. It also can encourage settlements. But we have another person with a lot of experience here.
And then we have two gentlemen in the back. But Enrique, please.
Yeah, so mine is more as an alum of third-party funding. And talking to the first critique of why it's unpopular for some, I would liken it to the situation of lawyers, right? I don't think anyone objectively dislikes lawyers, or maybe no one in this room dislikes lawyers. Insurance companies, they have in-house counsel, they hire attorneys. They don't have a problem with lawyers, but they hate ambulance chasers, right? I think that's the line, the distinction you need to draw. Everything done wrong, done in excess, done abusively is something that's going to have a bad reputation. Now, large, reputable, well-funded litigation funders are, like the attorneys in this room, right? They go after meritorious claims. They invest in claims that should be litigated, and the ultimate goal, obviously, aside from having a healthy return, it is at the end of the day a business, is to have everyone on equal footing. Now, as
So, but and again, just to clarify the misconception, do third-party funders have to agree any settlement proposals or not?
No, they
No.
don't have to be a part of the settlement agreement. Now, obviously, there are, depending on the commercial, on the third-party funder,
Yeah.
there is
A minimum that they need to receive.
right that they need to receive, and if a settlement is not commercial, there can be a right to arbitrate against the party that is agreeing to that settlement. Now, if the settlement is found to be commercial by a third-party arbitrator, and this is expedited arbitration, then the third-party funder agrees to it, and it is what it is.
So it does impact just in the sense of now that there's a floor, right? That there's at least that the claimant will have an incentive not to go below that, because then it might be liable for anything below that.
Right, but ultimately also the claimant can find other ways to give back to the funder what belongs to the funder.
Right.
Right? It's not like the funder can't step in and block a settlement. The funder can't do any of that.
Yeah.
But the funder is entitled under their funding agreement to a return from the money that they dispersed pursuant to that agreement.
Yeah.
So that's the only nuance I would add.
Great.
Yeah, I mean, I think I don't disagree with anything that's been said by the two other speakers. We're a third-party funding advisor. I think the key here often is access to justice for the claimants,
Yeah.
who may well have been extremely financially damaged by the dispute in question, to the point where there is no way that they could afford to bring this action without some sort of external investment. So that right of access to justice and that availability of capital to them is absolutely crucial for them to be able to bring the action in the first place. The issue of alignment is very important, and again, as an advisor, but also working with funders who subscribe to that thesis. The idea is that basically we are all aligned. Everyone's working towards a common goal here. And of course, there is not a perfect goal for everyone, but there is certainly an acceptable, I would say, combination of alignments that can achieve a common goal. What I would say is that there are some funders out there who are probably more aggressive in terms of trying to have an input on settlement than others. In any industry, you're going to have players like that. It's the same in private equity, it's the same in venture capital. So it is important sometimes to have someone in the mix who can, for want of a better word, police that. But on the whole, funders are there to make a profit on their investment for their investors. And I think the alignment piece is key, because that does tend to achieve a common goal.
Yeah. So we've heard a lot of agreement. There's a lot of agreement. I'm hoping for some disagreement. Who doesn't like third-party funding?
I think we can bring about this agreement after Luis shares his contribution. When we look at security for costs,
Yes.
there's going to be something that maybe third-party funders don't like.
You're not going to get much disagreement out of me. I would just, first off, with respect to settlement, I don't understand the issue. Funders, every time I've spoken to a funder, they want settlement. They want settlement early and often, because they don't want to be waiting 5, 6 years to get their money. The first thing they ask me, do you think we can settle this case within 6 months? So I don't see the issue. And if at some point the party wants to settle on terms that the funder didn't anticipate, well, generally that must mean that something went south in the case, and the funder doesn't want to keep on funding.
Yeah.
So I don't see the issue. Finally, I don't see the issue with third-party funding at all. I think it's another method of financing, and it's generally very intelligent people trying to find something to disagree about. That's a personal perspective. The security for costs, again, I think that's a very touchy subject. Most funders will not agree to do security for costs. I think that's, again, I believe people, states try to make third-party funding a much bigger issue than it should be. The fact that you get third-party funding should not immediately say, you're impecunious, you have to, put in security for costs. No. I may want to use what few resources I have to keep my business afloat.
Of course. Yeah.
And so, I am decided to go ahead and give 50% of my winnings away to the not because I wanted to do that, but because I made a judgment.
Yeah.
So the concept of security for cost, again, security costs are appropriate in certain circumstances. I don't think the fact that third-party funding was available, the same thing as if I got, you have a contingency from your law firm.
Yeah.
Now, does the law firm have to pay security for cost?
No.
It seems to me all arbitrary in that regard.
I agree with you, and I think third-party funding is, I mean, I think typically think about it for claimants that cannot bring a claim, but third-party funding is also, can be used by companies that do have the resources, but just want to, put those resources somewhere else and share the risk. So I definitely agree with you, and but there's been some, yes, pushback from states on third-party funding. I don't know, Fernando, if you have a view, or anybody else on third-party funding. I mean, when you see third-party funding and you're representing, I mean, I understand that most of your practice is representing states. When you see third-party funding on the other side, what's your immediate reaction? Do dynamics actually change, or is it more or less the same as not having third-party funding?
Well, honestly, in my practice, I haven't seen that.
Yeah, it's working now.
No.
In the case I have been involved, I haven't seen that many third-party funding.
Okay.
But I think that the main concern is actually, first of all, we're discussing security for cost. I mean, who's going to pay if there is, if you have let's say, an insolvent claimant, and the state believes that the claim is frivolous, or it doesn't, doesn't have any merit. Who's going to pay then if the award is in favor of the state, or if the claim is dismissed? So I think that's one of the major, I think, concerns. And then obviously to know exactly who's the funder, that the information is disclosed, because also, as we know, especially in investor state arbitration, you have to see whether there is you have to see whether that there are any relationship to the arbitrators, and the third-party funder. I mean, obviously the state wants to have full disclosure, knows exactly who's the funder, and all the potential relationships that might be problematic. But I think those are the two main concerns. I think disclosure and who's going to pay for the party if things, don't go the way the claimant wants.
And one more question just for you, since you already have the microphone. Does it influence your perspective on the merits and the claims when you hear that there's a third-party funder behind, in the sense that, they probably did thorough due diligence and they decided to fund this claim? It might be meritorious or not at all. This doesn't, no.
Not really. I think
Not
you
really.
have to look at the claim and,
Okay, independently of
Yes,
third-party funding.
independently.
Okay.
In
Over
the back?
there?
I think this discussion goes only not for investor state, but also for private commercial arbitration, where I've seen some parties saying that they need funding from somewhere else because they are practically broke. But I understand that third-party funders normally review these cases. Actually, they retain other firms normally to say, can you take a look at this claim to see whether it has merits or not? Because they are not going to risk, obviously, funding a dispute that is meritless. So I think once they start funding is because there are high or milder possibilities that they might be winning. So at the end, I think that tribunals will not condemn that party normally, because you have this, the chances of them being condemned, the claimant in case of investor state, is practically very, very low. So I think this concern about the government saying, that's a problem because if I win and then I have to collect, I cannot go after the third-party funder. I think this is ongoing discussions. I think they are now, everybody mostly agreed that they have to at least reveal who's the third-party funder for conflict checks and all of that. And I think the next step will be probably setting a standard saying when would the party funder actually pay for, because normally this party, like they said, it's the access of justice on one side saying, well, they are broke maybe because of your fault. Someone decided this is a good investment in terms of third-party funding. But if you really lose really bad, I think someone should compensate the state for going into that arbitration. arbitration.
Mm.
But I think that standard has not been set yet, and that's where we are.
Maybe our final comment?
Yeah, final comment, lady here, and then we need to pass the ball to Francisco for the closing.
A great way to close with Florencia. Authorize.
No, the only thing I was going to say is that, of course, funding is generally non-recourse. So, you only get your money back and any return if you win and collect. And it's all, about risk, the risk you're facing. If the direction this is going is that now there's going to be a requirement that funders will have to also take the risk of an adverse awards, you're just going to be making more expensive. And it's going to be harder for litigants to get funding. And the reason why funding exists to get access to justice to solve all these litigants with meritorious claims, because obviously if it's not meritorious claims, you're not going to fund it.
Yeah.
You have no recourse. You're going to lose all your money. So if that's what we're trying to achieve, and we're putting more obstacles, it's just going to make it harder.
Well, I think the prevalent view in the room is that we love third-party funding. So I think we're all happy with that, and it gives us work. So
Okay, thank you very much.
Thank you.
And it was a
Thank
lot
you
of
so
fun.
much for
Thank you for
your
participating.
participation. Thank you.
Thank you very much.
Thank you, Julio and Domenico, for moderating a very engaging discussion. Obviously, very interesting topics that are of interest to each one of our practices. 4 years ago, MIAS launched the first conference on investment state arbitration focused on Latin America with a vision. The vision was clear. There was a need for a platform for us, attorneys, experts, who are engaged in investment arbitration with a focus on Latin America to discuss and talk about these issues. And year after year, that vision has been confirmed, not only by the quality of the presentation, by the engaging topics that we present, but because of your participation, confirming that yes, there is a need for this forum in Latin America, a region that really depends on foreign direct investment, a region that generates about 30 to 40% of the investment disputes that we see in the world, deserves a platform in which we discuss issues unique to the region. Today, it has not been any different. It has confirmed the vision. Today, we have seen how important these political turmoil and situations are to the regime of investment arbitration. We started this morning asking the chicken or egg type of question. Has ISDS really fulfilled its mission of attracting more investment to the region? And irrespective of which way we feel about that question, it is clear, and I think it was unanimous, that it is a very important factor for the type of foreign direct investment that Latin America needs and hopes to attract in the future. Then we went on to discuss how the full protection and security clauses are so important to Latin America in particular, and what that means. What is the impact of that particular clause? What is that impact of that particular protection? And where do we go from there, from that perspective? And we've spent the entire conference talking about investment arbitration and issues that were unique to LATAM. Then we heard from Doug Bishop and how some of those cases that we take for granted, that we cite in our memorials and filings, really came to be out of nothing. And how cases in our region were so instrumental for the development of what we call this system of investment arbitration today. And after this discussion, we opened up the floor to questions, and we see how we come from different perspectives. From our experience, our shared experience, we come, we learn together. And that's what the Miami International Arbitration Society is all about. A forum, a group where we all come together with our ideas, our experiences, and we improve Miami as a venue, as really a city that is really welcoming and key to the development of arbitration in general, and we see investment arbitration in particular. I want to thank the organizing committee specifically. I want to thank Sylvia Marchilli, chair of the conference, and the entire team. Great job, Sylvia. Please join me in recognizing. I want to thank our very gracious host, FIU School of Law. This venue has been amazing. Thank you, Dean Gomez, for making this a reality. I want to thank each of our sponsors who have made this conference a reality and have really subsidized the entire arbitration week that we started yesterday. Thank you to our sponsors. And I want to thank each one of you for staying until 5 o'clock. It is 5 o'clock. The buses are ready. But really for being part of this amazing journey that we have in the Miami International Arbitration Society. And for those of you who are not yet members of MIAS, join the bandwagon. I mean, this train is leaving the station. We're going to continue to build on the success of years of hard work and dedication. Become a member of MIAS today. You have a great opportunity. If you look at the program, you're going to see how you can become a member of MIAS today. To the extent you're not a member yet, participate in the upcoming events in the Miami Arbitration Week and just join the discussion. Let's continue to make Miami a great forum, which has always been. We don't need to make it great again. It's always been great. That was not a political comment, but it's just a comment that comes out of a lot of love and commitment to this city that has become really a beacon of light for international arbitration. Thank you. The buses are about to leave in probably about 5 minutes. Let's continue to enjoy this amazing week, and thanks for joining this great forum.